So with this, we come to the end of our opening session, and we now move forward with the first panel discussion, wherein we'll be looking at role of COC as a key stakeholder under IBC. And for the very important panel discussion, role of COC as a key stakeholder under IBC, looking at what lies ahead, we are delighted to have amongst us a very interesting panel comprising of some very distinguished legal luminaries. We are delighted that Mr. Ajay Shaw, partner DSK Legal, will be moderating the session. Welcome, Mr. Ajay Shaw. Mr. Ajay has been with DSK Legal for 15 years. He is recognized and respected for his expertise in areas of restructuring, insolvency, energy and infrastructure, project finance, mergers and acquisitions. Mr. Ajay's advice is sought in particular for legal and commercial issues pertaining to energy and infrastructure projects, including the bidding process for PPP, PFI deals, consortium agreements, amongst others. Warm welcome, Mr. Ajay Shaw, our moderator for the session. Welcome, sir. Moving forward for the session, we are delighted to have some very interesting speakers. We welcome Mr. Rajbeer Sachdeva ji, President Group Legal, JK Organization. Mr. Sachdeva was previously a Senior Executive Director and Group General Counsel at DLF Limited, and prior to that also worked as Global Legal Head with Ranbaxy Laboratories. Mr. Sachdeva has extensively worked in the domains of mergers and acquisitions, competition, antitrust law, real estate transactions, amongst others. Welcome, Mr. Sachdeva. We welcome Madam Veena Sivaramakrishnan. She's partner at Shardul, Amarchand, Mangaldas. Veena Sivaramakrishnan, ma'am, is a key partner in the firm's banking and finance and insolvency and banking practice with over 16 years of expertise. She has significant experience in banking, financial services, regulatory, insolvency, amongst others, and has been part of many firsts of her area of practice, the NBFC merger of Capital First, IDFC Bank, amongst others. Welcome. We welcome Dr. Mamta Benani, President 2016 of the Institute of Company Secretaries of India, advocate and India's first registered insolvency professional. Dr. Benani practiced as a company secretary for over 21 years and was a senior partner of Mamta Benani and Associates, having offices at Pune, Kolkata, Guwahati, Chennai, Mumbai. Dr. Benani is now practicing as an advocate and is also a consultant on restructuring, corporate and legal matters. Welcome, Dr. Benani. We welcome Aswini Sahoo, Executive Vice President and Chief Investment Officer, Asset Reconstruction Company India Limited. Aswini Sahoo is the Chief Investment Officer at ARSO, India's oldest and most respected asset reconstruction company. Aswini brings nearly 2 decades of experience in infrastructure finance, special situation funds, expertise in investment across capital structure of Indian corporates. Welcome. We welcome Sanjeev Pandey, consultant and former Deputy Manager, NCLT and Policy, State Bank of India. Sanjeev Pandey is an experienced professional with a demonstrated history of working in the banking industry. He also holds expertise in corporate insolvency resolution, financial restructuring, risk management, amongst others. So on that note, time now for us to get into the much awaited brainstorming on a very important issue here, that is wherein we look at the important role of COC as a key stakeholder under IBC. So at Legal Era's 7th Annual Insolvency and Bankruptcy Summit 2002, let's take the deliberations forward, requesting Ajay Shaw, partner DSK Legal, to begin the proceedings. Mr. Shaw, please.
Thank you, Dr. Amna. It was very interesting listening to Mr. Shardul Shroff, and it was very insightful. Taking off from there, I think the topic for discussion for the panel is the role of the COC being a key stakeholder under IBC. Now, as we understand, the IBC process basically involves a creditor in control process, which is the resolution professional while he's in the driver's seat, ultimately the entire process is under the supervision and oversight of the committee of creditors. And if you look at the statutory framework, various important powers have been vested onto the COC. And thus it becomes very important to understand the role and functions of the COC and whether the COC needs to be regulated or not. Interestingly, IBBI came up with a concept paper in terms of, as to the background, why a regulation was required for the purposes of regulating the conduct of the COC. And they have cited various instances like the Sterling Biotech matter, wherein a 12A application was allowed at the fag end of the resolution process. The second instance which has been cited is a situation where the creditors have approved a payout to the legal counsel for work done prior to CIRP. The third instance which has been shown is where the COC has been able to take money out during the moratorium period. Now, these instances, I would think, are more an exception rather than the norm. But nonetheless, these have been the situations which has driven the IBBI to come up with the paper and a discussion as to whether there is a need for having a regulation or to monitor the conduct of the COC. It is in this context we can start our discussion, and we will open the discussion with views from, whether there is a need or not for a regulation. So I would request Mr. Sachdeva to give his views first, and then we can follow in the sequence.
Thank you, Ajay, and thank you, Legal Era, for inviting me for this summit. We'll start with the legal precedents. While fairness of decision taken in a corporate insolvency resolution process am I audible?
Yes, you are audible.
Okay. The fairness of a decision taken in a corporate insolvency resolution process have been intensively debated. And this is an intensively debated question where the COC decisions have been challenged in various forums. And particularly when we look at the issues, the code envisages COC to be supreme decision-making body during CRP. As per if you go by the code, even though it is RP who is responsible for management of day-to-day affairs of the CD or the corporate debtor, it is the COC which has the complete, powers and given and responsibility to decide on all the matters which are critical to the functioning of CD. If you see section 28, the code also specifically lays down the act which can be undertaken by the RP only with the prior approval of COC, such as creation of security interest over the CD's assets, change in ownership, raising an interim finance. So COC has been given wide powers. And even if the resolution plan has been approved by COC, it has to be mandatorily required by RP to place it before the adjudicating authority for its approval. Now, when you see the challenge under the judicial forums, we have seen the catena of decision where Supreme Court time and again said it is COC which is a body and decisions of the COC cannot be interfered on the merits, since the commercial decision taken by COC is something which is supreme, and there's a limited judicial review available to see that the COC, which has taken into account the fact that corporate debtor needs to keep going as a going concern, and during the insolvency resolution process. In the K. Shashidhar case, this objection was raised, but the Supreme Court discussed the aspect of approval or rejection of resolution plan by the COC, and clearly came out that the judicial scrutiny on the COC decision is quite limited. One cannot go into the aspects or interfere on the merits with the commercial decisions by the COC. We come to the case of Arthur Mittal versus Satish Kumar and Swiss Ribbons. Again, the emphasis was laid down on the role and responsibility of the COC, which said the feasibility and viability of resolution plan, the eligibility of resolution plan etc. All this is within the preview of the COC, and these questions cannot be, their decision cannot be raised. However, the Supreme Court in the SR Steel, they came out that there is a limited judicial review still available, which can be seen in the COC decision in the aspect that three things one should look into. One, that the corporate debtor needs to continue as a going concern during the insolvency resolution process. Second, it needs to maximize the value of the assets of the corporate debtor. And third, the interest of all stakeholders, including operational creditors, have been taken care of. Interestingly, whenever there has been a challenge, the Supreme Court has come and said decision of the COC is something which is final, and one cannot substitute the commercial wisdom by a judicial wisdom. That being the position, I think at present the judicial position is clear. Decisions which have been taken by COC, those have been respected, and those have not been questioned by the judicial forum at the Supreme Court level.
So what is your view? So do you think it should be regulated or no? Do we need a regulation for conducting the activities of the COC?
See, for the time being, while IBB has come out with certain suggestions, with the judicial precedents in place, we don't know whether decision of COC, which is a paramount and which has been taken into consideration by Supreme Court in various cases, will that be a question on the commercial wisdom? One can see in the context of let's see the Singapore laws. In the Singapore laws, there's a formal insolvency process of Singapore. The limited insolvency practitioner is called judicial manager. And if you see, the resolution process is supervised by the court. If there are certain issues raised on the functioning of the COC or the judicial manager or the judicial manager who has been appointed to run the CIRP process, those come and they are amenable to the jurisdiction of those courts, and courts look into this aspect. Same is the view. Look at the UK, and I've seen certain judgments in the UK where, while there is a wide power of administrator, but in order to avoid any misuse and the rights which have been provided to a creditor to challenge the administrator's conduct, there have been decisions where the challenge is made before the court, and if it is seen that it has harmed the interest of a creditor, or he has acted unfairly, or there has been misfeasance by the administrator, those decisions are set aside. Unfortunately, we have not seen in the context of Indian so far judiciary where such issues have been decided or taken care by the Supreme Court. So at the moment, right now, as per, I'm not talking about the IBBI, the suggestions which has come, but as per the judicial decision in various cases, the COC decisions have not been interfered.
Okay. Veena, what's your view?
Thanks, Ajay. And I think my personal view is that any sort of over-regulation is counterproductive to the development of any legislation and what it seeks to achieve. When we talk about a code of conduct, we are not talking about something which is binding in law, or which is it's more like a good practice, more like more like what you should follow, good principles, good governance, and things like that. But is there a need for that? I mean, at the end of the day, we are talking about moral and ethical sort of principles which are already laid down in the code and the regulations, and people are expected to behave in a certain manner when they are in the car which is driving this entire process, right? The resolution professional is obviously the driver of the entire process, but you are still given the responsibility of driving it. My other, legal sort of a view on having any sort of code of conduct for a committee of creditors is that The creditors can be anywhere in the world. They are not restricted to India. And IBC as a code, obviously leaving aside cross-border insolvency and things like that, as a code, it's an Indian legislation, and it does not have extraterritorial applicability in that sense. I don't, my worry on a code of conduct generally, because it is more procedural and not substantive, and because it is something which is reiterating behavioral norms and not really the law itself. It is not substantive in that sense. I personally don't think that there needs to be a written rule for a committee of creditors. I do appreciate that they play a very critical role in the entire CIRP process, and it's more of a duty of responsibility which is imposed on the creditors, and they need to respect that. But we also need to recognize that these are professionals, and therefore they need to be able to exercise and behave in a professional manner, and not necessarily have a set of rules which governs their behavior. So I don't think it's required.
Ashwini, I think having heard Veena where she says we do not need a regulator, but we need some kind of a code of conduct, what would you subscribe to? What should this be?
Like, my view is that, I agree with Veena in terms of any, evolving framework which is getting evolved today, we should not be over-regulated. And more so when today we see any resolution process is going on, people go to get a stay, and the process itself drags on because they question the transparency of the process. They question various things as per whether it has been done correctly or not done correctly, right? We have seen the things not getting concluded in a very limited time. It's getting dragged on for a long time. So should we also open another Pandora's box saying this is a prescriptive rule, so that we also, give an ammunition to people to challenge the process itself? And when today we are, the total struggling in the closure of the IBC process is because we don't have a timeline of closure, right? And more we give a more prescription, probably the party which is affected by it negatively, he would always try to get a, legal stay or not conclude the process, which I'm very worried about, if you ask me. So I would not like any further, probably, a prescriptive code at this stage.
Mr. Pandey, your views from a banker's perspective? Sir, you're on mute.
Yeah, thank you. So the concerns which are in the public domain regarding the functioning of COC, I think are emanating from few areas. Like one is competence. People not attending the COC regularly, every time new person coming to attend, having no background of the matter. Then decision-making delayed, violating moratorium provisions at times. Some of the bank having a heavy share of vote in a COC is just bulldozing his way through the decision-making. Then stepping on the role of IP, like in determination of claims, influencing appointments of professionals. So all these concerns are there, I agree. And for these, we do need some kind of code of conduct, which puts everybody in the same place and ask them to behave in a proper professional manner, as Veena shared. At the same time, I totally agree with Veena and Mr. Sahoo. Putting it into a law will be counterproductive. Already, I see that when the code was drafted, it was a very compact and very clearly drafted law. But ultimately, we went into reams and reams of regulations, and now it has become very, very compliance heavy and complicated to follow the regulation. So the code itself may be 20 pages, but regulation runs into maybe 2,000 pages now. So that I don't think will be helping the COC in any way or the process. If I may go through some of the drafts, because I was part of the committee in IBA who drafted a code of conduct. for the COCs. And if you see, mainly the concerns are coming from the moral or ethical part of it, or some efficiency maybe, like the maintain integrity in performing its role. Then not misrepresent the facts or situations. Maintain objectivity. These are the kind of inclusions in the code of conduct. Now, if you give it in the hands of a lawyer, you are a senior lawyer, Veena will agree with me, how this will be treated in a court. So these are very open and vague terms. If you leave it to a court to adjudicate, then I think your entire COC action will be litigated and we will reach nowhere, and time-bound process will take a big hit. So my view is that I don't think this should be by way of a regulation. Again, there'll be a problem of who will regulate, because generally COCs mainly consist of banks which are regulated by RBI. There may be some other corporates who may not be regulated. So COC is partly regulated only. IBC has no handle as per the current law under IBC over the COC or the bankers or the financial creditors. So I think it will be very difficult to implement the regulations. So my view is that let it be a self kind of regulation, as Veena said, maybe some best practices code or something, and then advocacy, and like you should train the people who attend COC in a big way so that they behave in a proper manner. And I think most of the banks, at least in State Bank I have seen, and most of the banks have a very, very large and extensive training system. So I think what is required to counter these whatever constraints are there faced by COC is more training, more advocacy, and some kind of self-regulated code of conduct. That's all. Thank you.
So in summation, I think what is being, what precipitates, it's more the behavioral issue of the COC. It's more the process and the procedure. It's more the efficiency. Now, these kind of issues under a code of conduct, which is self-regulated, like we can draw parallel from the advertising industry where they have the ASCII code. An ASCII code is not a regulation or a law. It's a self-governing or self-formulated code with which all the advertisers comply with. So something to that effect possibly is a way forward. At least I think that's what I'm hearing from the panel over here. And that code of conduct, maybe the IBBI can formulate in discussion with the bankers. And as far as it being a subject matter of legal debate, it should clearly be clarified that it should not fall within the definition of law or for the purposes of challenging a resolution plan, either under section 30 subsection 2 or section 61 subsection 3. Because if that is the case, then we are again opening up a Pandora's box in context of the overall processes of challenges. Any other remark if the panel wants to make on this? Okay, we can move on to the next sub-point, which is recovery versus resolution. Now, there is always a dichotomy in terms of, whether it is a recovery process or whether it's a resolution-oriented process. But if you look at the way the IBC has been framed and the way any creditor decides to proceed with the IBC, at least personally, I would believe that it is more a recovery and resolution plan. Yes, recovery is in the back of mind of every creditor, but ultimately it is for the purposes of resolution that one adopts IBC. Because if it was mere recovery, then one could have resorted to SURFACI DRT, which is otherwise available to lenders. Having said that, there is still a huge debate on context of recovery versus resolution, as was seen in the Siva Industries case, the Videocon Industries matter, where, ultimately when the COC votes for a resolution plan also, then the questions are asked whether the recovery is adequate as part of this resolution process or not. So it's a double-edged sword. Now, given that context, we would like our panel to discuss, what do they perceive the IBC to be? Is it a recovery or a resolution process, or it is a recovery and resolution process? Mr. Sachdeva, opening remarks.
While the object of IBC is for resolution and revival of the stressed asset, but I think when the banks or financial institutions, they file those applications against the corporate debtor, their motivating factor is for initiation of CRP processes because of the bad debt or the stress asset having been declared NPA. I have also seen, while Mr. Pandey is on the panel and he will have more experience on these things, the opinions are taken by the bank instead of, the IBC. Should we have a sort of, taking actions or under the SARFACE or any other recovery methodology by which the amount which has been paid to the corporate debtor can be recovered. Incidentally, the motivating factor becomes, the amount which is due and recoverable from CRP, from the stress asset, and in that process, the CRP process starts. I don't think, the object of IBC, with the object of IBC that we have to revive and resolve and rehabilitate the stress asset, the applications are filed, at least by the financial institutions. And when they start the process, they are always of the view that we will try to recover this amount. But then the CRP process starts and COC comes in, and then you start looking into the haircut and other issues, inviting the resolution applicants to submit their plans, and then trying to see which is the best plan for rehabilitation and to maximize the value of the stressed asset. I think it is a recovery mode which becomes a motivating factor for the CRP process to begin with.
Veena, your take on this subject?
When the IBC came out for the initial 2-3 years, the standard line we used to use was the objective of IBC is resolution and not recovery. Like it was this standard line we used to tell the clients and at forums, etc., saying the objective is resolution, the objective is not recovery. So don't look at it from that perspective. And that is obviously what the IBC also provided for as a legislation. But as things evolve and as you sit through COCs, as you sit through CIRPs, you sort of realize, and it's sort of a hard realization, at least personally for me, that the creditors are not running any sort of a pro bono service, right? It's more, at the end of the day, they have given money and they need to recover that money. So any resolution without recovery, when you have put the COC as the key stakeholder, and not just the key stakeholder, the most important stakeholder, is just not possible. So I think while resolution can be an overarching principle, I don't think today the way we are, or today the cases that are getting referred to IBC or what have got referred to IBC, there can ever be a resolution without recovery. No creditor is going to approve a plan which gives him nothing but resolves the creditor, right? I mean, we have to sort of test the we have to sort of test any principle as with the possibility of a worst case outcome. And the worst case outcome in this case is there is resolution but no recovery. And is that possible? And obviously it's not possible. So I don't think while the objective is resolution and therefore the principle is that the company should continue as a going concern, but I think recovery is an inherent part of it, because the corporate debtor till date has survived with the money which was given by the creditors. It's not their own money that they have utilized to reach where they are or to be in the financial state that they are. So I don't think these are two different concepts anymore. They are two sides of the same coin and they need to coexist to survive.
Thank you. Aswini, now, just from an ARC perspective, when you acquire NPAs, you are required to resolve and recover. What's been the change in approach ever since IBC was, brought into the picture?
Yeah. So, see, our first and foremost, objective of ARC is a reconstruction where, resolution is first priority, while not losing the recovery side, like how much we are recovering out of the case. So all this goes hand in hand. We don't isolate, one aspect from the other, saying that we have to resolve this, but we are not mindful of how much recovery we are going to do. So first and foremost, when we sit down to strategy making about how to resolve a case, so we list down which steps to be taken and in what priority steps need to be taken so that we achieve our end objective of maximization of recovery. Okay, that is our end objective that we want to get. So having said that, the challenges are many actually. Just we cannot just look at a resolution in isolation. Okay, because if you see, the challenges happens is that there are very limited bidders are coming into the case when you are going to put it in the part of the resolution process. And moment they realize there is just few bidders, they always try to get at a cheaper value the resolution done. Okay, while the asset value is much higher, so they always will try to acquire it at a much lower value than the asset, which also put the process into jeopardize, because then that asset value is high, how you can sell it at a low value, right? Second is that the working capital, when it is with RP, who is giving working capital? Unless the proper working capital is given to scale up the operation, the value maximization also doesn't happen. So today that framework is not properly evolved out. Who is giving this, incremental working capital so that the utilization levels are increasing? And second is that we don't have a robust as a probably a mid-market economy. The larger cases will find a better realization, a better resolution, because the assets quality are probably better, and they can scale up more faster. But a mid to small cases is extremely difficult because the merger and acquisition market has not evolved at all in that segment. So even if we all like to resolve an account through selling it to another probably interested party, this is where we are struggling. We are struggling because we don't find enough buyers. So there is no solution. There is no saying that this is the way. If we go, we'll find a solution. There is actually no solution which today I can think of.
That's a very interesting point. Thank you, Dr. Banani, for joining us. So I think Ashwini's point on having a corporate debtor being run as a going concern is key to a resolution. And I think he kind of precipitated the point that there are various difficulties and challenges of running the company as a going concern during the CIRP process. Now that gets to the root of the issue. When we talk about a resolution and a recovery, a resolution presupposes a going concern and ability to run even during the CIRP process. Your experience, what have you seen? The CIRP process, is it being used more as a recovery or a recovery and resolution process?
Question is to me, Ajay ji?
Yeah.
Thank you so much.
Yeah.
Thank you. A very warm good afternoon, and thank you for inviting us to this. It's a very pertinent question, and maybe I would like to just talk about my experience, because I'm the country's first insolvency resolution professional and have been working into this field since then. I'll say that it is actually restitution. What I have observed is even if it is a recovery for some, and if we feel that it is going towards recovery and it is not about resurrection, I must say that even the government realizes and mentions in various documentation that the cases which get settled just by filing the matter, especially by the operational creditors, if you see the IBBI document, Insolvency and the Bankruptcy Board document, even they claim that this much amount has been settled out of the court even by simply filing the matter. So by filing the matter, an operational creditor gets his pie and gets hold of it because it has not entered into the insolvency by then. And the government recognizes and actually triumphs over it and says that, look, so much has actually come back to the economy. So when you read the statement of objects and reasons of the BLRC especially, we find that one of the very major things that they have mentioned is to have a robust debt market. And when can you have a robust debt market? When all the money that has got stuck into old assets or sick assets and closed assets, they're actually put into use, and the money that then gets churned into the economy and changes hands. So that's how the debt market goes up. And what do you mean by debt market going up for the benefit of all? We all understand, just to mention, that definitely the money is available at a lower cost because the supply is also there then. So I personally feel that even if in the insolvency game, sometimes, there's always a race between this restitution, resurrection, and recovery. Even if it is a recovery at times, it is actually helping resurrection of the economy. And we are all a pawn in the economy, right? In whatever format, king, queen, or whatever. but we are all people who are in the game of building up the economy. So having said that, it's only at times, we encounter a situation where the financial creditors sometimes kind of thinks that they're in the waterfall mechanism. They start thinking even in CIRP as in liquidation. In liquidation, only the waterfall mechanism comes in, not in restitution mechanism. But somewhere or the other, the resolution plan has started being made as if it is heading towards liquidation. So I think by summits like this, we are actually trying to tell people and sensitize people that it's important that you give the share of the cake to everyone. And let's not just eat it alone. We understand that banks' money is public's money, but even operational creditors getting money is helping them not to get sick, because then it's a spiraling effect. So that's my preliminary comments.
Thank you, Dr. Banani. Mr. Pandey, what are your views when a banker looks at a IBC process? Meaning, what is in their mind? What plays out?
So, my point of view, because I worked in the stress asset vertical of the bank, where most of these accounts are concentrated from the regular account. Whenever they become distress or NPA, they are migrated to the stress asset vertical. And I think most of the banks have this kind of structures. Now, the brief of these verticals, stress asset vertical, initially was like even in SBI, it was the only recovery. Only in somewhere in 2018, at least in SBI, the focus of the vertical was changed from recovery to resolution. So the name of the vertical was changed from SAMG to SARG, Stress Asset Resolution Group. So basically, the bank wanted to change the focus or the way bank has to do. But ultimately, the people who are manning the branches and not participating in COCs, their promotions, their budgets come only for recovery, not for resolution. That is the bottom line. And it's for all banks. So I agree with Veena ji, when you sit in a COC, ultimately the driving point is recovery. But now we are in the 6th year of IBC, and we have seen ups and downs and the negatives and positives of IBC. So we are all aware. So if you look at the 17, I was with IBBI at the time, and in 16, 17, initially the banks were just gasping for capital and recovery. So most of the initial focus was recovery on. Most of the cases taken to IBC, only onus was we recover as fast as possible. Gradually now, and second thing was that most of these accounts were stuck as NPAs for years. So many were NPAs for 10 years, many maybe 5 years. And at that time, limitation clause was not included. So most of the banks took these accounts for the purpose of recovery to IBC. But after 6 years, we have seen, earlier we thought that within 9 months we get a resolution and we get a good recovery. And actually we got very good recoveries in few large cases. So now we can really scrutinize and discriminate and see where my best interest lies. And I have kind of 4 options today. Like I have an option of settlement with the borrowers. As Mamta ji said, a lot of cases are getting settled out of court even after filing in IBC. So that is another idea that bank file goes for IBC. Purpose is maybe to pressurize a settlement. Because ultimately, if you get a good settlement, which is better than a resolution and it's time, you get it within days with low cost, I think that is the best solution we get. So you get your recovery, you get a better recovery and very timely with less cost. So we have a compromise option now. Then we have a recovery suit option, which I don't think many banks may be going with because it takes 7 to 8, 9 years and you get a degree on it. Then there is SARFAESI and IBC. So today, as of today, I can see the positives and negatives of all these 4 options. And I see when a bank is going for invoking IBC, then it should go for a resolution. There are some economic and fundamental basis for that. Why? Because under IBC, you can sell a going concern, a unit as a going concern in a time-bound manner, which brings a higher value. Because it is an economical fact, and it's the fact we have realized in the last 5-6 years. If you sell a business as a going concern, it has a much higher value than a business as a stalled concern. Because that business value goes away the moment business is stalled. So you only get the asset value for a stalled business. So that is first economic principle where we should look for resolution. Second is the recovery through resolution plans. If you see the data of the last 5 years, so we have seen in SBI and most of the data available on IBPI website also. Generally, I can put a figure of around 30-31% of recovery through resolutions. And through liquidation, which is the recovery side. If you take a company to liquidation, then basically you're going for recovery only. There, the recovery has been less than 10% of the claims. So this is again puts focus on resolution. If the banks, the COC and the RP should strive for a resolution because you get a better recovery there. Third thing, time-bound manner. Of course, IBC started with a very tight timelines, and now after Rainbow, I don't know how long it will take. But again, the data, the facts show that the resolution has happened within say 400 to 450 days. And then you got a recovery around 30%, which I don't think even under Surface C or DRT was possible. Only maybe compromises where you get a better value. I think then you can do it more efficiently than IBC. So looking at all these factors, now it is for the bank or the COC to decide what to put first, whether recovery or resolution. So if you are going for a solution through IBC, I think my suggestion is put resolution first. Recovery is make it a byproduct of resolution. If you put recovery in the front, then you are not abiding by the fundamentals of IBC. You are not doing justice to other stakeholders. So I think it's a matter of priority. So if you come to IBC and you do it as a strategy, you don't have to come to IBC always. You have other options, as I said. But if you decide to go to IBC, then you go for a resolution. And it will be win-win for both. And then all the things come with that, that COC should behave, the RP should be provided interim finance. All this come with this mindset that if you are going for resolution, to agree for prompt decision making, agree for interim finance to maintain it as a going concern. So all those things comes as a package. So my point is only you have to keep it a priority as a resolution and keep recovery as a byproduct under IBC.
Thank you, Mr. Pandey. So very well said. I think ultimately it matters that a resolution is brought about, but at the same point of time, it should be a resolution to also help recover. And I think the key element is to have the corporate debtor as a going concern, and whatever is required for that purpose, I guess, should be the role of the committee of creditors to ensure that the company is actually being run as a going concern during the CRP process to value maximize. Thank you all for this.
Ajay, I have a point here, and what I think Mr. Pandey explained. We acquired Sirpur paper mills through the CRP process. The insolvency process here, when we started, it was filed by an operational creditor, Messrs. Rama Road Lines, Rama Transport Road Lines, a transporter. And ultimately, it went to CRP process. During the CRP process, we were one of the resolution applicants, successful resolution applicant. Our resolution plan was accepted by JK Paper, filed by JK Paper. Incidentally, all the banks, and this was declared as NPA, they had not resorted to the IBC as a mechanism to, rehabilitate or so-called where we are debating here. The proceedings were pending in different forums in Hyderabad, in other jurisdictions, including 138 proceedings, 138 Negotiable Instruments Act, Surface C by IDBI. And when CIRP process started, everybody came and joined the CIRP process. So just to say, I think Mr. Pandey said, banks have been saying we should only go for rehabilitation. At least my experience about 4 years back, banks were not in the fray of filing any IBC. It was only an operational creditor who got nothing because of the waterfall mechanism. But ultimately, banks were then became the COC, and they took the decision on how this rehabilitation plan has to be seen in the context of this test asset. So just to add, I think recovery is the motivating factor. I don't know, today, same thing happens. Banks, they keep taking opinions from various lawyers and law firms that what is the best way of recovering this amount. So if nothing happens, then they go to the IBC. This was my only one point I wanted to just...
I'll add to that, Mr. Sachdeva, because I have been closely associated with that particular matter Sirpur paper, and that is one of the most successful resolution I have seen in my career of like 6 years.
So this went up to the Supreme Court, and
yes. It's
Shardul Amarchand, Mr. Shardul Shroff himself was
ultimately,
advising
I
us
think
on
JK
this.
paper took over.
Yes, JK paper took over, and this was challenged. Unlike SR and other cases, we were successful till Supreme Court. One of the dissenting financial creditors, central bank had challenged it. Yes.
Yeah, why the bankers were reluctant initially to go for IBC? I'll maybe answer that. See, initially the concern with the banks was that if we take the company to IBC, it will accelerate the provision. That was the basic concern. So today my account is substandard. Okay, and at that time I think 17, 16, we were making only 10% provision. Today I think it's 15%. So bank is happy only to provide 10% and let go for 1 year. So at least 1 year, up to 1 year, we are comfortable to provide only 10% of the NPL. So the bankers were not clear because RBI has not yet clarified if we take the company to IBC, what will be the provision for that. And then under this list of first list 12 accounts, 30 dozen, when it came out, the circular, there was a mention that immediately after you take this company to NCLT and immediately on admission, the banker should provide 50% provision for that. So that was the clause that came with it. So that became the norm. Now today I have an account substandard or maybe doubtful where I have to make maybe 25% provision and I take it to IBC. Suddenly I have to make another 25%. I am talking about a time where all the banks were in deep losses, including State Bank. We declared losses for almost continuing 6-7 quarters. Banks were gasping for capital, and now suddenly you take it to IBC and provide 50%. So that was not the right thing to do. That's why I think most of the banks were delaying this initiation. Later on, RBI came out with clarification. This 50% provision is only required for these particular 12 and another 28 list of accounts. All other cases, normal provisioning will continue, and then the bank started. So to answer to your question, thank you.
So no, my only short point was it was not the initiation of CIRP by the banks or by the financial creditor. It was an operational creditor who started the process. So
I will tell you, the first one to initiate maximum cases in the IBC. One day, Dr. Sahoo called me, Pandey, you are deputed by State Bank. You tell me why banks are not making use of this very good law, which is basically drafted for the bankers for recovery. That were the words of Dr. Sahoo. So I said, sir, two things. One is this provisional issue. Second thing, bankers will take time to understand the law, and maximum cases were being filed by the promoters. Forget OCs also. In initial 3 months of IBC, December, January 17 and February 17, you look at the data. So maximum cases were filed by the promoters under Section 10. It is only after 29A came, then that promoters have taken a back seat, and now OCs are the biggest initiators. So again, there are incentives and disincentives. So I can see that now the incentives are better to go for IBC for the bankers than they were earlier. Thank you.
Thank you. Interesting perspective. And also, I think it's very important to note that, if you have a company which has to be resolved, if you want it to be resolved, then, getting it to IBC earlier may just value salvage. While this is, of course, a commercial decision, but the provision of the law is intended for that purpose. We move on to the next subtopic, which is justiciability of commercial wisdom. Now, this is an interesting facet because when a resolution plan is approved, the check on the resolution plan is section 30, subsection 2 and 61, subsection 3. Everything beyond this technically falls within the realm of the committee of creditors and its commercial wisdom. Now, is that a right approach? Are there concerns? We'll open up for discussion. Mr. Sachdeva, your reaction?
I have already touched upon this subject in my opening remarks. I think again I'll reiterate. See, judicial decisions start from the SR and now the Shiva Industries case. Those rulings clearly indicate that commercial wisdom of COC cannot be questioned by the courts, except on limited grounds. Those 3 grounds have been given by the SR judgment. Shiva Industries, clearly, the facts were and I can just point out the facts were clear. The IDBI filed an application under Section 7 of the IPC for initiation of this CIRP process against Shiva Industries. NCLT initiated the CIRP against the corporate debtor by admitting this application. But during the CIRP, the resolution plan could not be approved, and consequently, the RP filed an application for liquidation of the corporate debtor. During that application was pending, the shareholder of Shiva, who was also a promoter, he filed an application under Section 60, subclause 5 of the code, seeking consideration of one-time settlement offer by the COC. And that was allowed by the NCLT, and they directed the RP to convene a COC meeting to consider one-time settlement offer. After detailed deliberations, the settlement was approved by the COC with about 94.some% vote. And RP filed an application thereafter, after the COC had approved the settlement offer, for withdrawal of the CIRP process. However, the NCLT rejected the application for withdrawal of CIRP. Matter went in appeal before NCLAT. The appeal was rejected. But when matter went to Supreme Court again applied the principles and said the withdrawal of CIRP of the corporate debtor was completely justified. It is in the realm of commercial wisdom of the COC, which has paramount status, and without judicial intervention, COC decision should be seen as a paramount decision in all these cases. So question comes, while NCLT and NCLAT, they were debating from the judicial perspective that the application could not have been withdrawn. And one of the reasons they had given that this was a business restructuring plan, and this settlement could not be seen as a settlement under Section 12A of the code. Having said that, Supreme Court overruled these decisions and said COC is a final decision maker in all the commercial aspects, and their whatever decision they take, their commercial wisdom will have to be seen in that context. And finally, judicial interference will be minimal in all these cases. So in India, so far, the position remains the same. And I think I also touched upon the Singapore laws and UK laws, where at least these issues are justiciable, and courts do look into these aspects, whether commercial wisdom, because ultimately commercial wisdom has to be seen in the context of whether the COC has applied the law, applied it correctly, whether all the settlements have been done properly, etc. Now, so far that we have not seen, at least I have not come across, unless Veena can, advise us, and Ms. Mamta Benani can advise us, where Supreme Court has interfered in the decisions where COC has already approved a resolution plan or rejected a resolution plan, etc. And those decisions have been reversed. This is my view, looking at the current state of affairs in the Indian context.
Veena, over to you.
That's actually rare, Mr. Sachdeva. It doesn't really happen in that sense. But see, when we talk about commercial wisdom, I think it cannot be anything without fetters, right? At the end of the day, we do understand that the COC plays a crucial role, and as an authority which has lived through the entire CIRP process, they know better about the corporate debtor, and they know better about the lenders and inter se rights, etc. I think when it comes to commercial wisdom, just as principles, two things which need further fine tuning when it comes to commercial wisdom being interpreted is this entire treatment of dissenting creditors and respecting differential creditors based on the security interests that they have. I think this is where the law still needs to evolve and settle. I think as far as intercreditor rights are concerned, it is anyway outside of CIRP, but when it comes to differential security interests, differential creditors and their rights, I think commercial wisdom needs to still recognize that. Commercial wisdom cannot be the maximum decides or the majority decides and the minority follows. the entire principle of cram down of dissenting creditors or cram down of unsecured creditors, the law on that still needs to evolve, is my limited perspective.
Mrs. Banani, your take on the matter?
I can absolutely resonate with what Veena said. So if you see in commercial wisdom also, there has been a judgment of the Honorable NCLAT, Justice Mukhopadhyay, when he actually said, he's spoken about the distribution mechanism. So he didn't speak about the fact that at what price you have been able to sell the corporate debtor, but how is it that you have actually thought over the distribution? If you recollect, the operational creditors actually were made to be given more. So commercial wisdom, in the sense they don't want to interfere, is because you decide the price. It's a buyer's market, it is a seller's market. You decide mutually what is the price that you want to sell at, or what is the price that the person is willing to buy at. But definitely the wisdom is under check when it is to be distributed. Now, when you see a resolution plan, what Veena mentioned about the dissenting creditors and about the discrimination, I have been privy to many cases where still the resolution plan, which has been approved by the COC, of course, taking into consideration the supremo of the commercial wisdom, has been hanging in the court because of the discrimination made in distribution. Now, you may say that Section 53 is very clear. And why is it there's a fight over the discrimination issue? There are fights because the matters still needs to get strengthened, which is with regard to the security interest factor. Now, if you recollect, Regulation 38 of the CIRP regulations had seen a change. And it said that it may give weightage to the security interest factor. But basically what we see today is the voting interest. Whatever voting shares is allocated to the creditor in the committee of creditors is how we are seeing that the resolution plan fund is getting allocated. But to take a leaf from there, if you see that the unsecured financial creditors are also a part of the committee of creditors, they are not being given the share of pie as per the voting rights, because there the buyer feels that okay, we need votes, we need, and which basically belongs to the secured financial creditors. So there is an interplay of lot many things. It's exactly not the commercial wisdom alone. The buyer also puts in play a lot of mechanisms in a manner where they feel and understand will enable them to buy the stressed asset. So may I just also mention that when we talk about commercial wisdom, the COC, if it is also in a sense, it is recovery, and I say this with responsibility, what is so much wrong in it? Because ultimately the money has to come back in the economy, and as long as we carry the asset, it loses its value. As we know that the machines gets distorted, it gets devalued, and today something which we buy today becomes redundant tomorrow. So the sooner we are able to get this asset off our back, the better it is. So definitely the last point, which maybe as a summary, as what I'm saying, I would like to say is that it has to be a responsible act. It has to be by way of an application of mind. The matrix, the evaluation matrix should be actually designed in such a way that all the stakeholders get some share of the pie, and not only the secured financial creditors should be able to play in an empty field.
So Ajay, if I can come in, just to add what Ms. Binani said, see, the time and again, Supreme Court has been saying there is a limited judicial review available by the NCLT and CLAD in all these reviewing the decisions of the COC. Look at the case of Kalpraj. In Kalpraj, I think the resolution plan was submitted beyond the time, and Kotak, they challenged it. They won before NCLAT. Supreme Court reversed it. Now, if COC decision, then they again reiterated the same principle. COC decision is paramount. Here, there was a technical objection. Plan was submitted beyond a time. Still, Supreme Court did not come to the rescue of Kotak. So I think what Ms. Binani is saying is only applicable at the NCLT or maybe NCLAT. Let us look at the jurisprudence at the Supreme Court level. I'm yet to see a law which has been declared by Supreme Court, which has said less decision by COC was bad in principle and this was not applied properly, yet to see any of those judgments. Sorry, I interjected, but I think you can now.
So I think interesting perspective. See, ultimately the resolution plan, when it is approved, there is already a set parameter in terms of looking at it, whether it is in compliance, including if it is in compliance with applicable law. So that provision is already provided for. Veena's point on security and priority of security in context of voting. Now, this is something which is happening on the ground level. I think we all recognize the concept of priority and security and subservient nature of security. But using secured creditor in a homogeneous bucket is what is the legal issue. And I think that is what has not been addressed, creating, the various conflict of issues or conflict of interest. Now, given that context, Aswini, how are you seeing things where you are a secured creditor? Do people ask you to be treated same way as a subservient charge holder, or how do you normally react in such situation?
Yeah, Ajay, that's a very valid point actually, because if you see the lending framework in India or wherever you take, lending framework actually first addresses the what is the security creation, priority security creation and priority of cash flow, what cash flow is going to what, right? When a company goes to NCLT, anyway, you forget about the cash flow prioritization. It doesn't matter anymore. And if we are also forgetting about the security creation framework, then we are questioning the basis of judgment in which the lending is happening. That is very important. Then what basis the lender who is going to lend to a borrower, what would he rely on? Like if he is giving a first charge security, generally he's commercially, then he's trying to get probably a lower rate in that deal, or he is getting probably better, he structured that deal such way that he took the first charge on security. Okay, so by doing that, so today is in a situation like we know if this is not getting recognized in a way and he is not getting paid in that process, then tomorrow it is going to affect in a bigger way how he is going to lend to these companies. So COC wisdom, in whatever way you see, if it is not even justifiable, but amongst the COC, this security prioritization, cash flow prioritization, whatever contract was signed, we have to show basically how to respect those contracts. Today that framework is not there at all.
Mr. Pandey, actually, you will be a right person to answer, because normally we have seen a bulldozing by working capital lenders in a COC where they are normally a second charge holder, but they happen to have a component of first charge basis the term loan. And in that situation, it is convenient for everyone to be trying to be treated on the same standing. And I think that is where a lot of issues inter se creditors have arisen or have been swept under the carpet. And though the bankruptcy committee report recognizes the priority, under section 53, it's not explicitly mentioned. Given that context, this is where I think the commercial wisdom is being used more in context of a floor management amongst the lenders. Your take, sir?
Yeah, actually, that is the beauty of IBC, that you don't not only have to get a plan, you have to get it voted also, to get it approved. That is where some give and take, element of give and take comes in. So COC take multiple commercial decisions. I think here we are trying to focus only on resolution plan, but my view is that there are umpteen kind of commercial decision taken by COC during the course of CRP, including the decision of right at the outset whether to continue CRP or take it to liquidation. That is the biggest decision taken by COC in the very first or second meeting. Because for a defunct company which is lying closed for last 5 years, you need not go for a resolution plan. You know already that there are no machines maybe on the land and building. There is no scope of revival. So you take it to liquidation. That's a big commercial decision, and you cannot leave it to the court to decide. This is for the creditors to decide. And I don't think they are doing injustice to anybody by taking this decision for early liquidation. Then similarly, the decision to select RP. So right now, I think COCs have not understood the concept of selection of RP, because they are going by the L1 kind of a situation where the lowest bidder they take. But as we grow mature in IBC, we will see that some of the RPs will have their domain expertise. Some will have expertise in the steel industry, some may have in cement. And then we have to look for the right person for the job. I think Mamtaji would agree with me, because every RP cannot be expert on every industry. So you have to pick up a right person who can take the process through to the right conclusion. And then he has to have some background, some experience in that industry, either way of running a CRP of that particular industry, or maybe coming from that domain. Then the withdrawal under 12A, that's again a commercial decision. I think multiple judgment in Siva industry we're talking about. Supreme Court said it is a commercial decision. That's a very big decision. And maybe it is affecting the applicant also, who has initiated the plan, but somewhere his interest is protected because he has to consent, he has to agree for that kind of a arrangement. Coming to the resolution plan and this commercial decision of approving the plan and selection of resolution plan and selection of resolution applicant, that's a very, very crucial decision, because you can pick up a good plan, but ultimately whether that plan will be implemented is also a big question mark. We have seen almost 10 to 15% plans not getting implemented under IBC. If you see the IBA data, 15 to 20% plans have not been implemented or have been frustrated for one reason or the other, or are being litigated somewhere. The applicant has approached the court for withdrawal of the plan. All these things are there. So I think COC has a much bigger role in vetting the applicant, then vetting his background, whether he can bring the funds for the plan, his experience, whether he can really turn around the company, and then actually the commercial terms of the plan, what exactly he's putting up in the plan, whether it's technically feasible, economically viable. I have seen plans where the numbers don't match. Like I went through the DSCR and the cash flows, and it doesn't justify the repayment schedule under the plan. These are simple things to verify. So the problem is that COCs are supposed to take this commercial decision, but somewhere because of, I think, in some of the, I will not say all, the members are not competent enough to go into so much detail. And most of the time we come back to that question of recovery and resolution. So they only look at the recovery part of the plan. That is where I think the questioning is coming, why the COCs are not doing proper work, because they are not justifying their actions. They're only looking for recovery. A plan comes, he says, I'll pay 100% upfront, and blindly they approve. They don't look at whether he can pay, how much who will get. Immediately, and even if he's offering 50% of another plan, which is offering maybe double the amount over a period of 5 years. So all these things, I think, require some more input by COCs. But coming to the other part of regulating these commercial decisions, I think that will be very, very counterproductive, because entire IBC is created or drafted on this premise that the commercial decisions and the other legal decisions are separated from the adjudicating authority. So they are kept out of the purview of the judges. Exactly why? Because we have the experience of RDB Act, then we have BFR, where the judiciary was found totally wanting in taking commercial decisions, and neither in time-bound manner nor applying their mind, because they are not experts in finance. That was the idea behind giving the powers to COC. But now problem is that every person sitting in COC may not be a finance expert. That is where problem lies. So I see going forward, maybe some kind of structure will be created, which will not exactly be a judicial review of the commercial decision. At the same time, maybe some informal structure, like the court can ask some senior chartered accountant, somebody, to look at the plan and look at this commercial angle, whether it has justified whatever. That kind of structure may evolve over the period, but I am not a votary for judicial review of commercial decision.
Thank you, Mr. Pandey. I think we're running short of time. I think this is also in line with the Mehir Mafatlal judgment, when 391-94 schemes were there, that commercial wisdom should remain with the stakeholders who best understand the subject matter. With this, thank you very much. Very interesting to discuss with all of y'all, and thank you once again.
Thank you.
Thanks.
Indeed, a very interesting session. Thank you so much to our wonderful moderator, our speakers. Very interesting session, pointing out towards new dynamics that we must try to see with respect to the role of COC. Thank you so much.